Hello, I'm Erica Minchella. I'm going to be talking to you today about the new multi-board contract referred to as the 7.0. I'm going to be focusing on two particular paragraphs that we'll go over in some detail. The new contract that we are using in the northern part of the state, it was a collaboration between about 13 real estate brokers and 7 real estate attorneys. The intention in revising the contract was to make sure that changes in the way people do work in real estate is addressed, as well as certain deficiencies that were seen in the prior contract were addressed. Two paragraphs that I want to focus on today are paragraph 10, the attorney review, and paragraph 12, the inspection review. In paragraph 10, the attorney review paragraph, there are 4 choices for the attorney to make. Either approve the contract, disapprove the contract, make a counteroffer on the contract, or make a modification of the contract. I want to pay attention particularly to the counteroffer or the modification. If you are in paragraph 10C making a counteroffer, that is the same as in any other contract. If a counteroffer is made, the other side can simply terminate the contract and say that we're not going to go forward. But the 7.0 contract has a provision in it to allow for further good faith negotiations. It allows you to continue negotiating for 10 days from the time that the contract was accepted. That allows you to not just throw the contract away and say the parties aren't going to proceed forward, but to really give you an opportunity to see if there can be a meeting of the minds. If you are going to be making a counteroffer, you want to make sure that you're designating that your counteroffer, that your modification, the change that you're making is under paragraph 10C. On the other hand, if you just want to make an adjustment to the contract, such as to provide that the survey is going to be provided a day before the closing instead of at the closing table, or title will be provided 5 days before the closing so that the lender has an opportunity to review it to get to clear to close on time, or if a date was misstated and really winds up on a holiday or a weekend. That's just a modification. And if that modification is rejected by the other side, that doesn't provide for an automatic termination of the contract. Paying attention to the distinctions between those two provisions in paragraph 10 is going to be very important, especially because the contract provides that if you do not designate that the modification that you are seeking to make is under paragraph 10D, it's deemed to be under paragraph C, and it's a counteroffer, not just a modification to the contract. The other paragraph you should pay particular attention to is paragraph 12 regarding inspection reviews. That paragraph has gotten very specific with regards to how the requests can be made, and there is limiting language as to what can be asked for. You can only ask for certain items to be repaired that are major components, and there is a list limiting what the major components are, as opposed to the expansive list that we had, or no list that we had in the 6.1. It's particularly important to pay attention to that, because if you are making a request that is not within the major components that are listed in that paragraph, you can have your contract denied and terminated and you're done. Whereas if you are paying attention to what you can ask for, you can request certain things that are based on safety and health. The other concern you should particularly have with regards to this paragraph is if there is a major component that is not in that inclusive list, what you may want to do is write an attorney review letter before you write your inspection review letter to ask that that list be expanded to include the issue that you want to be able to address. Once that's been included in attorney review, you then have the opportunity to ask for it in inspection review, and it gives you an opportunity that you don't have under the contract itself. One other thing you should be paying attention to in that revised paragraph is that as the buyer, you are not entitled to send a copy of the inspection report to the seller unless the specific items in the inspection report have been requested. That same language comes up in the as-is paragraph, so that you are not just allowed to send off the inspection report and get an advantage in negotiations by providing information that the seller might not otherwise have had and now has to disclose, so that the buyer has some advantage in doing their negotiations for an agreement on the repairs for that property. The contract has many revisions in it. If you are not a regular practitioner in real estate, you need to make sure that you spend some time reading the contract through and making sure you understand what is going on with these changes. And if you are a regular practitioner, I'm sure you'll become familiar with it and will be able to talk to your real estate colleagues about what changes you're going to need to be making to your attorney review and inspection review letters. To learn more about the benefits of joining our ISBA Real Estate Law section, please visit the ISBA website.